into the instruments that govern employment and labor relations. I want to give you comfort that you're on safe ground. Ours is a forum for discussion. We will be constructive, we will be objective. So what I'm doing here is really just highlighting some of the major trends and issues and areas that we as employers would like us to work together on and think more deeply on. Our coming together as employers in these symposiums is driven by FKE's desire to engage members deeper and better as we see the different developments and the changes that are happening in the world of work. It is changing rapidly. It calls for us to be innovative as actors and players in this field. In particular, we want very open debate on the key instruments and laws that we rely on to do our work, primarily as labor relations practitioners from all spheres. Here we have lawyers, we have people from the corporate world who are our members, we have our trade union representatives and social partners, we have you now, the judiciary, and we have consultants who I think are a bit, they are able to look perhaps a little more objectively than we were deep into the system and ask us some deep questions as people who are doing human resources, practicing law, managing labor relations. We as FKE deeply appreciate the role that the judiciary plays in our economy, and in particular the Employment and Labor Relations Court, which is an important institution that shapes jurisprudence of employment and labor relations in our country. In fact, as social partners, this is the one court that we interact with very closely and intimately by virtue of your work and your function. Over the last few years, the judiciary has become more open, and you have taken some initiatives to create forums, to dialogue, and to hear the voices of the ordinary people, the voices of employers, the voices of trade unions. These forums include the Court Users Committee, the Bar Bench Committee, the Court Rules Committee, the open days that you conduct, and also the Chief Justice Roundtable, where we as private sector come to a round table to tell the judiciary, to share with them what we're perceiving, some of our pains, some of our ideas, and the judiciary also talks back at us. So these forums have given us, ordinary people, the opportunity to interact with judges on what I call normal footing. Because judges are people that we are scared of by and large, unless you're lawyers who are used to them. But even there, they have powers, you know. They can throw you into jail, they can sentence you, but also I think they like hearing opinions on how they are doing. So that openness over the last few years has really made it possible, I think, for both sides to hear one another. And you being here today is one such example. One key question that we want to ask today is, what is the role of the Employment and Labor Relations Court in balancing the interests of the parties in the labor sector and that of business and enterprise? What is the role of the court? This one specifically because it is our court. Although it has joined the mainstream judiciary, and that is something FKE pushed for, because we wanted the Employment and Labor Relations Court, the industrial court as it was called, to be mainstreamed into the structure of the judiciary. But it has a specific role. What is that role? We cannot overemphasize how important the Employment and Labor Relations Court is, because the decisions that this court makes set and also influence the development of labor and social policy. And our entry point as a federation is really the labor and social policy angle. Of course, we do a lot more things around that, but that is our main entry point into the economy. It therefore behooves this court to be alive to the fact that it is a major player in shaping the jurisprudence on employment and labor relations matters, which not only guides court users on the practice, but also sets the industrial relations tone for the employer-employee relationship. So in our view, the court needs to factor in the new forms of work and the changes brought about by the advancements in technology on the future of work. It is a fact that solid and sound decisions create stability and support industrial harmony at the shop floor level, or at the workplace as we call it. Conversely, unpredictable or unfair decisions create imbalance and instability at the workplace. Today, we are privileged to have you, and I believe we're going to have open discussions. We look forward to hearing you and also sharing with us your perspective as the principal judge on the role of the court in developing jurisprudence on industrial relations and the future of work. We believe, since we know you are a brave person, you will also share with us the challenges that you experience in the dispensation of justice, and perhaps where we as business people, as employers, can improve, because that is the objective. Also, your perspective on some of the laws and the different hurdles and challenges that we brought upon ourselves as people who discussed those laws as they were being reviewed, and where we find ourselves today as a country. There have been advancements, first starting with the constitutional space that our new constitution brought about, but also there were improvements as we reviewed our labor laws, which came into force in 2007. And Judge Maureen was very active in trying to educate and create awareness amongst our membership in what those laws contain and portend. But I don't think any of us could envisage where we are today, where I think we're a very litigious society, not just in this sector, but as a country. So many cases, so much litigation, very little room for dialogue, for settlement of issues. Where did that spirit go? We can discuss that. So, court decisions have a serious impact on the business climate and the running of enterprises. That is indisputable. Ultimately, court decisions actually affect the cost of doing business, and that for us is a key issue. One of the emerging trends which were being discussed yesterday, which was never envisioned even in the Industrial Relations Charter and our practice of labor relations, is a multiplicity of unions. Someone was talking about it as a summary of one of the tables, I think. In some sectors, you have as many as 8 unions, especially the education and the transport sector. Can you imagine the kind of complexity managing labor relations is in those sectors? And we see it. They're always in the media. One problem after another. How did we get to this position? That is something we need to discuss. The complexity in the management of industrial relations. Also, the advent of the 2010 Constitution and the subsequent interpretation of various provisions of that Constitution have been litigated in very many different aspects, including aspects on employment and labor relations. This has also brought about its own challenges. There were issues of perception. Space had been opened. Anybody could actually start a union if they wanted. You could join any association. There are no limits. You could go on strike anytime. That is what we thought, especially those of us in the labor sector, that this freedom had come and it is unfettered. Is that so? Can it be unfettered? And I'll revisit that issue. So, the reality is that in the absence of statutory and constitutional provisions in these emerging issues and various challenges and changes, we depend as industry to a very large extent on the wisdom and sound decisions of various courts, particularly of the Employment and Labor Relations Court. We look to this court to provide guidance on what constitutes fair labor practices and what the roles and responsibilities of each social partner and other stakeholders are. Fair court decisions help us to minimize conflict and find reasonable and practical solutions that support business growth and business sustainability. We need sustainability for business to plan. So this court is duty bound, in our view, to confront the challenges that these emerging issues bring with what I call wisdom of Solomon. We all know the story of Solomon and his wisdom. That kind of wisdom takes into account the realities on the ground, the values that we have as a country and as people in this sector, and the continuity of enterprises, and of course, the welfare of the litigant. Such wisdom, in our view, would support business growth and sustainability. But one thing that we know as business people is that we play a very important role in creating jobs to allow Kenyans and other people living in this jurisdiction to work and be able to provide for themselves. The role of jobs in helping us move out of poverty and enhancing social cohesion cannot be overemphasized, especially as you see what's happening in the market today. So much stress that companies are going through, so much restructuring, so many job losses. But who thinks about the business person and the kind of challenges they are facing in running those enterprises? You see headlines of people who have been very influential, successful in this country going bankrupt. Perhaps they are overinvested, but perhaps the realities of the economy make it very difficult for enterprises. I'm sure if you took some sort of census around this room, you'd find 3 or 4 that are on the verge of restructuring, declaring redundancies, and reconsidering the kind of spend on people or new investments, because that's the reality of business. What is the role of the court in helping us maintain stability and being able to retain people in employment? I think employers are perceived wrongly that we are trigger happy to declare redundancies and reduce employment. I don't think that is so, because FKE really does not advocate for that, and we know it is done as a last resort. But this kind of wisdom that I'm saying should be Solomonic would, in our view, help us in addressing these issues and perhaps approaching the court with less trepidation than we often do. We as FKE support this court, the Employment and Labor Relations Court, and the judiciary as a whole. We always advise our members to follow the law and do what is right. So our interest is really in influencing that law in the formation stage so that the end product is something that we can live with. That's why, since there is willingness, I think now all around, to review and reform the laws, it's very important that we discuss some of these challenges. But we have also been pained as a federation and as employers to see court orders being ignored. We've discussed this, I've raised it with the CJ. It is very important that the courts, including our Employment and Labor Relations Court, be respected and be given the dignity that they deserve. But we know that in this country there's a culture of people ignoring court orders, and even in our sector. People are on strike, the strike is declared unlawful, the people are ordered to go back to work, they ignore that, but the government continues to engage with them. So we've been, and this particularly is in the public sector, we've been telling government as FK, but you see, at the end of the day, you are creating precedent and hurting the economy in ways that we cannot measure. Because if people are on strike, then how can you be conciliating? There used to be a time where it was obvious. If there was a strike, the first thing that we would aim at is parties to resume work, for normalcy to be restored so that conversation, social dialogue can happen. So I believe that this court should invest in building its brand as being an equitable, judicious, and consistent institution. And you can do this in various ways. I just want to suggest a few. One is justice, dispensation of justice, judicial justice. Yes, the court dispenses it, we're not doubting that. But, and I've said this and I'm often said, oh, employers like complaining, you have a persecution mentality. This I was told by the bigger judiciary, not the Employment and Labor Relations Court. But honestly, as we have assessed and seen the decisions coming out of the court, we believe that the court seldom places any contributory liability on the employees for their actions or omissions. By and large, that responsibility is placed squarely on the employer, and they face very serious consequences for that. So workers know, and you know, even the ILO is said to be a workers' house. So the Employment and Labor Relations Court over the years has always been seen as a workers' court, perhaps rightly so. But the eventual decisions that come out, I think there should be a balance. The workers should also know that if they do something wrong, they flout the regulations of the company, they commit fraud, or they commit offenses that amount to gross misconduct, or, you know, they should know that they will also face the music from a point of view of the law and how the court will decide. But right now we have a bit of an imbalance in the labor sector. In some cases, when employees emerge as the victors, perhaps in circumstances where you thought you had evidence, it creates a situation where employees want to go to court. They'd rather go to court than sit down with the employer to try and resolve the issues. Same with the unions. So unconsciously, as labor sector practitioners, we have fed into the high appetite for litigation in our country. And as I said earlier, we are fairly litigious. And in this sector, that was not what was envisioned, because it is based on social dialogue. So these workers and people who use the court services also know. Over time, they study, and they make an assessment of the kind of judgment you're likely to get from court A as opposed to court B. So there were instances where actually people were doing forum shopping, and you'd prefer to go before a specific judge than another one because you can predict what that decision will be. But I think there's a way of fixing this, and I'll come back to that later. As time has passed since the advent of the new laws, I think the line between managerial prerogatives and the human resource function in a company versus court decisions is getting increasingly blurred. This is evidenced in the issuance of preservatory orders that stop processes like recruitment process, redundancy processes, in some cases transfer of personnel from location A to B, and reinstatement of employees, and sometimes this is done before all the parties are heard. And so it's very difficult for management to manage. And I think this is what the industrial relations seeks to do, the industrial relations charter that we were looking at, the delineation of responsibilities. What are managerial responsibilities? What are union responsibilities? What is the responsibility of government? And what is the spirit within which these parties should work, so that if you go to court, it's really on a matter of law that you are unable to resolve at enterprise level or with the assistance of FKE and COTU. This line between management, managerial responsibility, and judicial responsibility, I think we need to discuss as social partners to be able to retain, because that's the only way to bring sanity to the workplace. Employers are also increasingly incurring costs from this litigation. Of course, litigation is costly, and you can't recover the costs. By and large, employers also face sanctions where we are ordered to meet the costs, which by and large is not balanced by similar orders against the workers. In fact, Judge, we believe, and you can counter this, that the courts rarely award costs to the employers, even when the claimant's case fails. So we always face the music, perhaps because we are the bigger brother, but employees, I think, would also be a little more careful in filing cases, and I believe in the right to file cases. That is not what we're disputing, but there should be a balance. Since we're discussing labor relations, one key issue we need to consider is how to exhaust the conciliation process before litigation. How do we get back the spirit of labor relations and commit to voluntary conciliation, ADR, so that we go to court as a last resort? This is particularly important with regard to economic disputes. There should be effort by the parties to resolve, but where there's an economic dispute, again, we want to emphasize the role of the CPMU in advising the court and assisting the court as envisaged to arrive at its decision, which is not always consistently followed. My last point in this area of what are some areas for improvement is the issue of jurisprudence. In law, we talk about the doctrine of stare decisis, which basically says that the case at hand should be decided according to the decisions made in similar cases in the past. Creation of precedent. So that there's an element of predictability in court decisions. Of course, each case is determined within its own facts, but where those facts are more or less similar, you'd expect some sort of predictability so that, again, there is stability and parties do not forum shop thinking they will get better decisions from court A or court B, because you know that if these facts are barely more or less the same, the decision is likely to go a certain way. That way we would be able to create jurisprudence for our sector, which I think is room for improvement. Let me conclude by re-emphasizing some of the issues I've highlighted. One is for us wanting to see the dignity of the court upheld and decisions and orders of the court being obeyed so that we can protect the integrity of the Employment and Labor Relations Court and indeed the judiciary as a whole. In terms of culture, when parties fail to do this, then even the litigant who perhaps would have benefited from the order that is not being followed by the parties that are flouting it is put at risk. So there is need for the court to enforce its orders, and we would be very keen to support that. The consistency in decisions I've talked about, I'm sure the court does it, but we'd like really to appeal for consideration of the impact of court decisions on industry and the economy at large, such that if a judge orders a 50% salary increase or 20% where an enterprise's growth and productivity in the year under review was 5%, then there's a problem. And this would help in terms of balancing the interests of the workers and the employers. The size of some of the awards, I think, has been an issue where the award is so manifestly huge that if an enterprise were to follow it, then you'd obviously then also lead to the reduction of the workforce. My final area as labor relations practitioners is the need to balance the constitutional provisions on rights and obligations. We have a situation where we have rights, which are good rights, like the right to strike, which is limited by Article 24(1) of the Constitution. We have the right to join an association. I've often talked about the quandary we find ourselves in balancing the right to strike versus the right to life. Like when you have doctors on strike for weeks on end, which right prevails? Where do we get this balance? How can we protect particularly the essential service industries or sectors from strikes? And this is one area learned Judge Maureen would like to work with the judiciary on, especially the Employment and Labor Relations Court and the unions. It's a sensitive issue, but globally, the essential service sector is protected from strikes, and you then have to put in place very stringent measures to ensure that the rights of the employees in that sector, yes, are respected, but at the end of the day, the right of the general population. How do we strike this balance? How did we get to a position where essential service sectors, the ports, airports, water services, can go on strike willy-nilly? And this would be a good point to stop at, because I think it gives us opportunity for further interaction. Once again, we want to thank you very sincerely for taking time over your busy work schedule. It's also fun to sit and have discussions with employers than facing litigants in court, hearing parties argue. And we really look forward to you hearing your address and to discussing some of these issues with you. We wish you well. Asante sana.
Thank you. Can we appreciate again our Executive Director? Thank you. We want now to welcome the Principal Judge of the Employment and Labor Relations Court to give us her address and perhaps make comments on the issues that the Executive Director of the Federation of Kenya Employers on behalf of employers has raised. Thank you. Let's do it the Oga way. I mean, the Oga way we had yesterday, they have a lot of energy. Can we show a lot of energy to our principal judge that we are happy for her to be with us today? Okay, we got the, okay, one, let's go, let's do it as we welcome the principal judge. Okay. One. Oh, with energy. 2, 3. Welcome our principal judge. Fungua. Thank you.
Good morning. I know there is a lot of expectation from me. There is a lot of bashing, a lot of, some people think we can do magic. We have a magic wand. So it's a pleasure for me to be here after very many years. I used to do this quite frequently when I was working in FKE, up to 2012, when I left to join the judiciary. So it brings nostalgic times, memories, when we used to do a lot of training for employers. And especially around the time when the new labor laws were passed, and we had to sensitize the whole nation on what those laws contained. So now I was told that I should talk about the topic, effective industrial relations, and not that, on jurisprudence on industrial relations and the future of work. A very restricting topic, if you look at it critically, but also very open if you look at it widely, so that you have to set the boundaries yourself. I'm looking at it in relation to the theme of this sitting, which is on the future of industrial relations and the world of work. So I had done a paper, but listening to the executive director speak, I was telling her, I'm wondering whether I should abandon the paper and speak on the issues that she has raised. But let me just give a very brief summary of what my paper is. Then I can address some of the issues that she raised, which I think are also a concern to me. But I will tell her in the future, when she calls me, she should have a sitting with me and tell me exactly what she wants me to talk about. So my paper is concentrating on jurisprudence, emerging jurisprudence in the world of work. And what I looked at was that work has evolved over time. If you were working 20 years ago, you'd have known some very big names which are no longer in existence now. Somebody was giving an example of Kodak. How many employees did it have 20 years ago? How many does it have today? Companies like Kenya Breweries, how big was it those days? How big is it now? East African Industries, Kenya Railways, do they still exist the way they used to exist? They don't. Why? Because of the way the workplace has evolved, because of the way industry has evolved, because of new changes that have come into place. So these new changes are what is changing the place of work. Unfortunately, our laws are not changing that fast. And again, unfortunately, the people we work with are not changing that fast. So that to impose what was working in the old setup onto the new setup. And that is causing quite a bit of conflict and maybe a lot of pain, disappointments in the place of work. So what are these new changes? I'm looking at the way we do work, for example. a lot of organizations are shedding off quite a bit of the work they used to do and either outsourcing it or using technology. Look at banks, for example. Some 20 years ago, there used to be very long queues in banks. Then they introduced ATM machines, reduced some jobs. Later on, they have introduced what is it? You can now get your money from your phone. You don't have to go to a bank. You can do all your transactions from your house. You can use your computer, do internet banking, or you can do M-Pesa banking, and you'll be sorted out. So what has happened? It means that the workforce in the banks have been replaced with technology. And it means that even the nature of work, the work that people used to do in the banks, like entering records and so on, is now done by the account holders. They enter, and then the bank, it's reflected in the bank records. So that the nature of work that a bank employee used to do 20 years ago is very different from the nature of work that a bank employee does now. And then you also ask, do we need a physical person in a bank? I know there is a Standard Chartered bank in, Junction, where there is nobody. You go and serve yourself. It's a whole bank, but you serve yourself. So do we need employees in banks anymore? So those are the issues that are changing. And of course, when these issues come, sometimes they find their way into the court. We have had a lot of redundancy cases. Most of you will remember the case of the tea plucking machines, which went all the way to the Court of Appeal, where the union was trying to stop the employers from introducing these machines because they are going to render a lot of people jobless. But again, you balance what is the benefit to employers, what is the benefit to employees. Can employees do the work the same way as the machines? So the court actually held that the employer has a right to manage its processes. The employer can carry out redundancies, provided it is done according to the law. So if you do it according to the law, nobody will fault you. So we stopped a few redundancies. I know Ms. Kanyiri was before me not very long ago with one where the redundancy had been stopped. But sometimes it's because of the way the employer interacts with the union, and sometimes it is because the employer does not comply with the law. So if you don't comply with the law, if you just give a notice of redundancy and the person comes to court, we will give him a remedy. We will stop the redundancy. If you do it properly, we will not stop it. We will allow the employer to do it. But again, the unions have abandoned the labor, the machinery, the pre-court machinery, and a lot of them are coming directly to court. And sometimes when they come under certificate, we do not chase them away. We cannot chase them away. But we would expect that the employer would come back and tell us, this person has not done A, B, C, D, so can you send us to the Ministry of Labor? Which we do a lot of times, sometimes even without being prompted. So parties need to comply with the law, and then the courts will normally not interfere with the functions that are supposed to be carried out by the employer. There is also the issue of outsourcing. A lot of cases come to us which have directly arisen from outsourcing. Again, the courts have said it is not wrong to outsource, but how are you doing it? If you do it the wrong way, then the courts will have a reason to intervene. If you do it the right way, then the courts will normally not intervene. So if you, like one case that I'm handling now, the employer tells people we are going to carry out, to declare a few people redundant, then all of a sudden they bring a labor company to take over all the labor force, so that the the impression that has been given to employees is different from what actually comes out. Then, of course, you also find that the employer has not complied with the requirements for redundancy as set out in the Act. And sometimes it is very painful because someone like me who worked with employers understands that stopping a redundancy is a very expensive exercise. It is very expensive to employers. So if you appear before me, I would want to finalize it within the shortest possible time. But in court, a year is a short time. Yes, if your case is handled within a year, that is a very short time. Because we have cases that are even 20 years old. I think the oldest case in the judiciary is about 50 years old. It's involving land. But a year for an employer who has decided to carry out redundancies can actually make you wind up that company, because you'll have to have money to pay these people for the whole of the time when the matter is pending in court. So it is always best to make sure that you start off on the right footing so that there is no reason for anybody to come to court. Then there is also the issue of remote work. A lot of jobs, online jobs, have been created, and sometimes you don't even know who is the employer of who. You don't meet your employer. You send work online, you work on it, and you send it back. So there are issues, again, which I think need to be addressed by the law. When you come to court and we do not know where to pigeonhole your case, perhaps we will handle it within the structure of the law that is available, which sometimes would not be appropriate. So again, this is something that is coming up. We've had a few cases. In one case, an employee was trying to tell an employer that, brought an employer to court saying she's an employee. The employer was saying, no, we do not have an agreement. You are not my employee. So which is which? If there is no agreement, most probably will say there was no employment relationship. But again, if the employee can prove that I have been given instructions and I have performed the work from home, again, we might hold that there was an employment relationship. So these are issues that are not very clear, and sometimes we will decide mainly based on the facts before us, not on the law. The other issue that I would have liked to raise, other than those few, is parties who work part-time. What is the nature of the employment relationship? You find that somebody works for 3 different employers, works morning for one, afternoon for another, works weekends for a third employer, or evening for a third employer. So when there is a dispute, how do you resolve this matter? Again, our law has not developed that much, has not addressed such a situation. For example, some of them will come to court. They've been working for somebody for 20 years or for 10 years, 5 years, they disagree. Somebody has been working every morning, every day, then they start asking for minimum wages, they start asking for leave, they start asking for many other things. How is the court supposed to address such a situation? If you are an employer and you're using such people, the best thing to do, can you put down all the contractual issues so that when a dispute arises, you can show the court, these are the terms under which we engage with this person. Some issues have also arisen about discrimination. And discrimination can be very wide. Discrimination on the grounds of age. I keep telling people that if you are an employer and you have no retirement age, if you retire me at age 65, for no reason, only because I am old, I can go to court and say discrimination on grounds of age. So, because the Employment Act does not have a retirement age. So what would be the reason for retiring me? Because I'm 61 years old, you tell me I can only work until I'm 60. So again, those are issues that employers need to tackle. Employers who pay differential rates, and this can be very sensitive. You have a CBA, you pay people according to the CBA. You have another set of people whom you call contract, you pay them very differently. You have another set of people whom you call casual or temporary, you again pay them very differently. You have another category of staff you call expatriate staff, you pay them very differently. When they come to us on the basis of discrimination, are we not supposed to listen to them? If you tell me we are clerks, I am called a temporary clerk. This one is called a CBA. This is a clerk who is covered under the CBA, and another one is called a clerk who is covered under a fixed term contract. We are all doing the same work. Are we supposed to be paid differently? So those are issues that employers need to address. If they come to us, we will look at everything and make a determination. Then I saw something in the program which is also an issue, dynamics of working with the different age sets. There is the people who are perhaps my age and older, who are used to working in a very stable environment where you know you will work until you retire, probably in the same organization. Very few organizations are offering that. And again, there are people who expect to be on your desk from the moment you arrive to the moment you leave. Is this what the current people who are entering the job market, can they work like that? So if you are a manager of employees, if you want to make them work the way you know how to work, perhaps you will not get the best out of them. Again, the people who are entering the job market now are people who do not want to be employed for life. They want to be free to move from one employer to another. They don't appreciate stability in employment. So again, it means that we have to work with them in a manner that creates the most, a manner that would make them most productive. A lot of them also do not want to wear formal clothes. You know, if you have a dressing code, there are a lot of organizations which used to have a dress code. Do you still have them now? And do these people comply? Will you not have conflicts over the way people dress when they come to work? So all these are issues that have to be considered. Of course, if they come to us, we will look at them. We will first look at your terms and conditions of employment. If it is provided for and the employee is bound, then of course we will go by that. If it is not provided for, then we will go to the Employment Act. Again, if it is not provided for, then we will look at what is fair. Is it fair for you to have treated the employee the way you have treated them? What has been the norm? Or how have you been handling such matters? Because all these are provided for. If you look at the Employment Act, it actually provides for all those. If you look at section, I think 45 of the Employment Act, 45, 46, it tells you look at the way the employer has been handling similar matters. So all these are issues that are bound to affect the job place. So that is a very brief summary of what was in my paper on jurisprudence. I have mentioned a few cases. I didn't do it on PowerPoint, but I will be handing it over. I'll give a copy to FKE so that they can share with the participants. Now, other issues which may not necessarily be on jurisprudence and which maybe I did not add onto my paper. Issues about wages guidelines. the executive director mentioned about the way we decide matters. A lot of the people who are coming to court now do not articulate themselves. If you are an employer, you come to court, the union is demanding 50%. You are appearing before a judge who has never been involved in negotiations of wages. What is your role? A role to educate the judge, because the judge will decide based on the understanding and the law. Issues like wages guidelines are not even in our law. Wages guidelines are supposed to come from the Minister of Finance. I don't know when the last guidelines were issued. 205. How many of you come to court with a copy of the wages guidelines? Do all judges know that there is a wages guidelines? If you are coming with the cost of living indices, how many of you come and tell us this is what the cost of living indices say, and this is what the guidelines say should be the compensation on inflation, for example, on productivity, and this is what the productivity in our organization was. A lot of employers will only tell you about affordability, and then they will not even give you their accounts, their financial performance, documents to prove their financial performance, so that the judge will be left with nothing but what the union says against what the employer says. And in such circumstances,